Section 21B, Legal Enforcement. 21.6, Law Enforcement Duties. All airmen should be familiar with the rules for apprehending, arresting, and confining violators of the Uniform Code of Military Justice, UCMJ. Apprehension. Apprehension is the act of taking a person into custody and the equivalent of a civilian arrest. An apprehension is made by clearly notifying the person orally or in writing that he or she is in custody. The simple statement, "You are under apprehension," is usually sufficient to provide notice. During apprehension, such force and means as are reasonably necessary under the circumstances to effect the apprehension are authorized. Military law enforcement officers, military criminal investigators, and persons on guard or performing police duties are authorized to apprehend persons subject to UCMJ jurisdiction. Although all commissioned, warrant, petty, and enlisted members on regular Air Force status may apprehend persons subject to UCMJ jurisdiction, absent exigent, urgent, or necessary circumstances, the apprehension of civilians should be done by law enforcement personnel. Enlisted members not otherwise performing law enforcement duties may apprehend commissioned or warrant officers only on specific orders from a commissioned officer or when such apprehension prevents disgrace to the service or to prevent the commission of a serious offense or escape of someone who has committed a serious offense. The immediate commander of an apprehended person should be promptly notified. Pretrial restraint. Pretrial restraint is moral or physical restraint on a person's liberty that is imposed before and during the disposition of offenses. Pretrial restraint may only be ordered if there is a reasonable belief that the person committed an offense triable by court-martial and if the circumstances require restraint. Factors to consider in ordering pretrial restraint include whether one can foresee that the person will not appear at trial or will engage in serious criminal misconduct while awaiting court-martial. Pretrial restraint should not be more rigorous than the circumstances require. Only an officer's commander can order pretrial restraint of an officer. This authority cannot be delegated. Any commissioned officer may order pretrial restraint of any enlisted person. An enlisted person's commander may also delegate such restraint authority to an enlisted member. Pretrial restraint may include conditions on liberty, restrictions in lieu of arrest, or confinement as briefly described here. Conditions on liberty. Conditions on liberty as a pretrial restraint are imposed by directing a person to do or refrain from doing specified acts. Examples include orders to report periodically to a specified official, orders to stay away from a certain place, such as the scene of the alleged offense, and orders not to associate with specified persons, such as the alleged victim or potential witnesses. Conditions on liberty must not hinder pretrial preparation. Restrictions in lieu of arrest. Restrictions in lieu of arrest are imposed as the restraint of a person by oral or written orders directing the person to remain within specified limits, but to a less severe level than arrest. The geographic limits are usually broader. For example, restriction to the limits of the installation. During restrictions in lieu of arrest, the alleged offender will perform full military duties unless otherwise directed. Arrest. In the U.S. Armed Forces, the term arrest means the limiting of a person's liberty. Arrest as a pretrial restraint is not imposed as punishment for an offense, but it does direct a person to remain within specified limits. Arrest is a moral restraint. No physical restraint is exercised to prevent a person from breaking arrest. A person in arrest is not expected to perform full military duties. Confinement. Confinement is the pretrial physical restraint imposed by order of competent authority, depriving a person of freedom pending disposition of charges. No person may be ordered into pretrial confinement except for probable cause. Probable cause to order pretrial confinement exists when there is reasonable belief that 1. An offense triable by court-martial has been committed, 2. The person confined committed it, and 3. Confinement is required by the circumstances. Each person confined shall promptly be informed of 1. The nature of the offenses for which held, 2. The right to remain silent and that any statement made by the person may be used against the person, 3. The right to retain civilian counsel at no expense to the United States, and the right to request assignment of military counsel, and 4. The procedures by which pretrial confinement will be reviewed. 21.7 Search and Seizure. The Fourth Amendment to the U.S. Constitution protects against unreasonable searches and seizures. The authorization to search must be based on probable cause, particularly describe the place to be searched and describe the persons or things to be seized. Probable cause to search exists when there is a reasonable belief that the person, property, or evidence sought is located in the place or on the person to be searched. Authorization to search is the military equivalent of a civilian search warrant. A search authorization is an express permission, written or oral, issued by a competent military authority to search a person or an area for specified property or evidence, or to search for a specific person and to seize such property, evidence, or person. Commanders, military judges, and magistrates may be authorized to direct inspections of persons and property under their command authority and to authorize probable cause searches and seizures over anyone subject to military law or at any place on an installation. A commander who authorizes a search or seizure must be neutral and detached from the case and facts. Therefore, the command functions of gathering facts and maintaining overall military discipline must remain separate from the legal decision to grant search authorization. 21.8 Inspections. An inspection is of a person, property, or premises for the primary purpose of determining and ensuring the security, military fitness, or good order and discipline of a unit, organization, or installation. Commanders may conduct inspections of their units. Inspections are not searches. The distinction between a search and an inspection is that an inspection is not conducted for the primary purpose of obtaining evidence for use in a trial or other disciplinary proceedings and does not focus on a particular suspect or individual. Contraband seized during an inspection, for example, vehicle entry checks and random drug testing, is admissible in court.